How mediation and labor arbitration councils work in settlement of labor disputes. During and after the COVID-19 pandemic, the financial health of enterprises have been negatively impacted, leading to management's decision to reduce costs through termination of labor contract with employee. The illegal termination of labor contract could lead to disputes between employer and employee, which sometime would cost the employer more than it gains. It is important for the employer to engage with labor lawyers to consult before taking the decision, to consider factors that would involve. After disputes arise, mediator or labor arbitration councils could be used for resolving disputes. Individual labor disputes shall be settled through mediation by labor mediators before being brought to the Labor Arbitration Council or the court, except for the following labor disputes which mediation is not mandatory. Disputes over disciplining under dismissal or unilateral termination of employment contracts, disputes over damages and allowances upon termination of employment contracts. Disputes between a domestic worker and his/her employer, disputes over social insurance in accordance with social insurance laws, disputes over health insurance in accordance with health insurance laws, disputes over unemployment insurance in accordance with employment laws. Disputes over insurance for occupational accidents and occupational disease in accordance with occupational safety and hygiene laws. Disputes over damages between an employee and enterprises, organization that dispatches the employee to work overseas under a contract. Disputes between the outsourcing employee and the employer using outsourcing employee. The mediator shall complete the mediation process within 0.5 working days from the receipt of the request from the requesting parties or the authority. Both disputing parties must be present at the mediation meeting. The disputing parties may authorize another person to attend the mediation meeting. In case the two parties reach an agreement, the labor mediator shall make a written record of successful mediation which bears the signatures of the disputing parties and the labor mediator. In case the two parties do not reach an agreement, the labor mediator shall recommend a mediation option for the disputing parties to consider. Where the two parties do not agree with the recommended mediation option, or where one of the disputing parties is absent for the second time without a valid reason after having been legitimately summoned, the labor mediator shall make a record of unsuccessful mediation which bears the signatures of the present disputing parties and the labor mediator. The disputing parties shall be entitled to request the settlement from labor arbitration councils in the following cases. A disputing party fails to perform the agreements specified in the record of successful mediation. Mediation is not mandatory. The labor mediator fails to initiate the mediation by the deadline. The mediation is unsuccessful. After the Labor Arbitration Council has been requested to settle a dispute, the parties must not simultaneously request the court to settle the same dispute. If within 0.7 working days from the receipt of the request, an arbitral tribunal is not established, or within 30 working days from the establishment of the arbitral tribunal, it fails to issue a decision on the settlement of the labor dispute, parties shall be entitled to request the settlement from the court. In case a disputing party fails to comply with the decision of the arbitral tribunal, the parties are entitled to bring the case to court. We help clients overcome cultural barriers and achieve their strategic and financial outcomes, while ensuring the best interest rate protection, risk mitigation, and regulatory compliance. A&T Lawyers have law firm in Hanoi, law firm in Ho Chi Minh City, and law firm in Da Nang.